Welcome back. Welcome back. It is Family Law Fridays, ladies and gentlemen. Yes. Yes. Bring it on. Bring on the smoke, man. The purpose of Family Law Fridays is to first and foremost educate you on the extortion that is going on in family courts and possibly equip you with the tools and knowledge that you need to maybe free yourself from such bondage or be able to at least stand up, have a backbone, and stand up for your rights. Those who do not act on their rights have none. Those who slumber on their rights have none. That's an equity matter. You must be vigilant. You must practice vigilance when it comes to exercising your right. So even if you get the no's and denieds, and you will have some losses, but don't give up. That's the problem. We lose and we just say, "Hey, I give up because I lost." No, it's not. You may have lost the battle, but you did not lose the war. But this is not legal advice at all. I am not an attorney, and this is not a law firm. I advocate that you had them in private. You did the do in private. The state wasn't there videotaping, passing you on the protection that you need to get in action. So if you had it, you did it in private. Take care of them in private, right? That's my thing. But this episode, we're going to talk. We're going to discuss a little bit about how they steamroll your rights in family court a little bit here, and steamrolling your rights, how they take your asset, extort you to unjustly enrich themselves. Yes, I said it. Judges and lawyers and the like are unjustly enriching themselves in family court. Did you know by terminating a parental right, and when I say terminate, I mean forcing you in a non-custodial parent position? I mean, who came up with that? This is a position that they created and that we put ourselves into unknowingly, voluntarily, uh, through force and etc. But they put you in these positions as a non-custodial parent by taking your parental rights away, and they make thousands of dollars, hundreds of thousands. They can make at least $100,000 just off of terminating the rights of one parent. I mean, yeah, it's 2025. I'm sure they could, and I'm sure they are. Okay, this is $1 billion budget we're talking about here. Billions. Most states have a child support as a third to two-thirds, and I'm definitely going to stick more on the two-thirds side of this of the state's budget is child support enforcement programs. That's how they're sustaining. That's why it's a big machine. It's very hard to defeat, especially if we're scattered like roaches when it comes to being uniformed in our fight and being fully informed on the laws that are to be enforced in these courts. Now, of course, we'll talk about later on how they will try to say the Constitution doesn't apply in this court. And, my question is, well, don't you have an oath to the Constitution? How can you say you have an oath to something that you're going to uphold and turn around and tell me that it doesn't apply here? So how could you be taking an oath to something that doesn't apply to the job you're enforcing? I mean, honestly, it's an act of treason, if you ask me. It's an act of war against the people. 80% of 80, at least almost 90% in most states have sole custody decisions. 80 to 90% is pretty high. So 80 to 90% of the time, a sole custody is uh, awarded to most of the time the mother. Now, in order to take a mother or father's, but mainly we're talking fellas here, the father's rights, if you are to prove that he is unfit, that's how you strip someone, mother or father, of their parental rights is by showing that they're unfit. Has the court, or not even the court, has the plaintiff who's coming after you and you're the defendant, have they proven you to be unfit? Have they produced the evidence, material evidence, not hearsay, to prove that you are actually unfit? They don't most of the time prove that you're unfit. Most of the rulings are based on hearsay information and how the judge feels. Okay. So if 80% to 90% of decisions are um, decided as a sole custody order, that means 80 to 90% of families that they are, coming in contact with have at least one parent, most of the time the father, that is unfit. That's what that type of ruling, or that statistic rather, is showing, that if you're going to rule to give someone sole custody of a child and unfitness has to be proven, you're saying that 80 to 90% of people or families have one person who is dangerous to the child. That's what unfit means. It means to be dangerous. You are a danger to the child, whether it be neglect, abuse, abandonment. It's a danger. It affects the child's mental health, their nutritional health, all these things, right? That's unfitness. Beyond a reasonable doubt, excuse me, is not the best standard of proof in family law or in civil cases. In this particular situation, family law, civil matter, can be turned into criminal, and we'll talk about that in another episode on how they try to morph a civil matter into a criminal action. But um, it has to be proven with clear and convincing evidence. Um, and that isn't being conducted. So they're automatically violating your due process of rights by not providing a evidentiary hearing to produce your evidence to show that you are a fit father, to show, or mother, or to show that you have not abandoned, neglected, or abused your child, to show that you have supported the needs and necessities and maintenance and care of the child. You haven't abandoned the child or given up the child for adoption or any form to the public. So let's be honest here. Are they doing that? No. Now, again, I'm not saying that there are not situations where fathers or mothers do need to be placed on this program where they are abandoning their children. They are refusing to provide the proper necessity and care and maintenance of their child, etc. They are unfit. But we can't just put this blanket on everybody and say that because the relationship didn't work out, you are an unfit parent. How fair is that? This is more of like a violation of the equal protections of the law, because now they're putting you in a form of a class, and this class of people um, have lesser rights. They're being treated with less rights. They've been having their parental rights stripped from them without just cause. Okay. Uh, and a lot of them do it from the position of what is called the best interest of the child doctrine. And it's a guy by the name of Dr. Warren Farrell. He wrote a book. I think it's The Father and the Child Union, is what it's called. Don't quote me on that. I could be wrong, but if I can remember, that's what it's called. And he's did a research. He's been and this book's pretty old, but he did a research it came out in early 2000s on his research regarding, he did a study, a meta study, which is the study of all studies. It's at least 225 cases around the world. And he actually proved that 50-50 custody was the actually the most advantageous position for the child. And not providing that is actually child abuse. I mean, any professor or doctor in the space will say that uh, removing a child from the mother and the father and providing one parent sole custody of that child and alienating the other parent, they would call it alienation. Truly, it's truly called alienation. When you are really forcing the child or forcing the parent taking away his rights, when you're forcing the parent having to enforce his rights through the courts to be able to see the child, and you're treating one parent as king and the other one as a peasant who has to pay the rent to the king, right? You're creating a lot of conflicting issues, and it's actually child abuse, uh, that you're alienating the child from the parent, and the toxicity that can be created from that um, unconstitutional manufactured relationship of a custodial non-custodial parent situation. It actually destroys family values, morals. It destroys the actual how can I say, the power of the father in this. I'm just going to say father just for now. It affects the father's right to the services of the child, right? When I say services of the child, I mean, like, back in the day, every child had a duty to keep up the estate of the castle, the home, and because that estate would be passed down to them. And of course, things have kind of changed, but they still remain the same on the principle. Uh, some way of keeping up the castle or your home is taking out the trash. That's the service of the child. You assign that to your child. You have the right to do that as a parent. The cutting the grass, right? Is to maintain the estate. When the child goes to work and he gets old enough to work, 15, 16 years old, you have the right to the services that child went to go work for. The child's still a minor. Yes, the child's money, they worked for it, they worked hard for it, but you still have control of the services of that child because you are the parent. Until that child becomes of age, then it's on a different footing. Okay. Uh, but they use the best interest of the child doctrine. And if it's truly in the best interest of the child, they wouldn't be making these kind of rulings that actually separate and alienate the child from the parent. That's child abuse. 100%. 100%. Hitler said it in one of his books that he said, uh, if you were to say you're doing it for the children, you can get people to do anything. That's Hitler. Say it again. Hitler said, if you were to tell them you're doing it for the children, people will do anything. And he also said the lie becomes easier the bigger the lie and the more you tell it. The bigger the lie, it's in the best interest of the child. The more you tell it, it's being pushed down everyone's throat. It's the spearhead of the family court system. And they use judges, um, lawyers to push it. Um, and then they use the media and politicians, the legislative body, to spread the lie. And just because the state creates a statute doesn't mean it's constitutional. Okay. Um, and then they do that to program people to believe in the lie when they spread it. Okay. Um, They believe most people are incompetent to actually manage their own family affairs, and we must have state intervention. This is far from the truth. But unfortunately, we as a people have accepted such. So it becomes the norm because we've accepted it. It doesn't make it right. It just makes it easier and normal, so to speak, because we've accepted that. No one challenges it, really. Okay. Um, and, you know, until we understand our state and federal constitutions, it's going to be a very, very hard uphill battle for a lot of us because they understand most of us don't have the comprehension skills to really know what's going on. Um, so, this best interest of the child doctrine is truly not in the best interest of the child. As I stated earlier, it's child abuse. Simple. Alienation. Simple. There's no evidentiary hearing to prove that the father is unfit, that he failed to provide the necessities of the child, that he abandoned the child. In reality, most of the time, it's the mother who takes the child away from the father or leaves the father. And I don't mean like your relationship didn't work, leave. I mean like, you know, she begins to alienate the child from the father. And the father then is forced to go down to the courthouse to obtain his rights, so called rights he actually already has. And truly speaking, the mother should be penalized for alienating the child. The father is trying to be a father. The mother should honestly be responsible for the repayment, so called, of the Title A benefits if she is at risk on being on social welfare. She should be entitled to paying that back if she can't produce that you actually alienated yourself from the child. You've actually abandoned your duty as a father, truly speaking. But there's no hearing for that at all. Your due process is violated off the rip. They're gonna act like, oh, it doesn't apply in this court case, but yet they have oath of offices to the Constitution. Actually, child support is a federal issue. It's not a state matter. These, they get incentives for enforcing child support. And actually, the program is voluntary to enter into. The state does not have to enter into a contract with the federal government to receive Title 4A benefits. But because it's such a big part of their budget, they do it. And then after they get reimbursed 66% on the dollar, they are able to participate in an incentive program. And they're not monitored on how this money is spent, truly, at all. But I don't. I'm not going to give too much today. I just want to touch on that a little bit here on this episode of Family Law Fridays, and you know how they use the best interest of the child doctrine to your uh, disadvantage. I mean, it's not really a good doctrine anyway. It can't be in the best interest of the child. Blessing versus Freestone already stated that child support doesn't give an entitlement to the mother or the child. It's really to reimburse the state treasury. So therefore, it's in support and benefit of the treasury, which is the taxpayer, not actually the child. So technically, it's false advertisement that you're calling it child support because many case laws states that it's not for the benefit of the child nor the mother. So how could you really call it child support? Blessings versus Freestone, you know. So just something to drop in you guys. on you guys today to kind of think about, but I appreciate you guys joining and tuning in today. It's been a long day for me. Got a lot of projects getting out the way. Your boy's graduating in a couple of days, Yes, yes, yes. Big pedigree, big dog status, It's another thing that I wanted to conquer on my to-do list before I exit this realm we call the 3D physical world. Yeah, so uh, I'll be coming with another one with in the next few. I think next week. I think it is. Yeah, I think we'll do another one next week. I might. I don't know. Might do definitely do another one next week. But yeah, I appreciate you guys tuning in. Again, this is for educational purposes only. Definitely start studying the jurisdictions if you're dealing with a child support case. Definitely, it's time. It's time to put put your boots on, strap them up, get in the mud. If you want change, and don't look at it as just change for you, but you're changing a whole generation after you because you never know. It might be your son on there. It might be your son on child support someday. So don't look at it as trying to avoid for the ladies. No, we're not trying to avoid. Right is right, wrong is wrong. .com.org, period. If I'm willing to support my child, the state should have no interest in it. And the only way the state should have a compelling interest is if, like I said before, they can prove that I'm in fact unfit or I've abandoned the child. Period. There's case laws on that. And if you're blind to see that, then that's you. You're refusing to accept truth because of your emotions. And your emotions rule, which means your EQ is a lot higher than your IQ. You're very dangerous if you base most of your actions on emotion. Besides logic, in fact. So, again, appreciate you guys tuning in. We're going to do another one here next week on Friday for Family Law Fridays. Got another one coming for Trust Talk Thursdays. And another one before that is both Wednesdays. Okay, we're going to try to get this going back to back. If not back to back, at least every 2 weeks. Definitely podcasts will be coming soon. Stay tuned for that. Again, if you like my content, please like and share. The only way I know that this is helpful for those out there and I can continue to create this content is if you like and share. Of course, I don't know how well I'm doing if you're not liking and sharing for me, family. So I appreciate you. And until next time, you guys stay safe out there. Stay diligent, vigilant, studious, and get that peace of mind you deserve. I'm out. Take it easy.